of new types of jobs and hence reskilling the workforce, which is also essential. At the same time, our Prime Minister is also trying to observe that Global South also becomes a force to reckon with as far as AI is concerned. In fact, I see Mr. Krishnan is also over here. Now, as we all know, we are living in a transformative era, one where we boldly push the boundaries of new age technologies while also remaining mindful of the challenges they bring. As AI continues to reshape industries, India is also striving to strike the perfect balance, fostering innovation under the Make in India vision, while also ensuring that AI serves its people responsibly, mitigating risks and maximizing its benefits. To shed light on the holistic regulatory frameworks that can guide AI towards a more constructive and ethical role in media, we are honoured to have with us Shri S. Krishnan, Secretary Meti at Government of India, for a fireside chat with Mr. Michael McNamara, who is a member at the European Parliament and co-chair of the European Parliament's AI Group. This chat will be moderated by Mr. Anil Malhotra, who is the head of Public and Regulatory Affairs at Zee Media Corporation. Sir, I'd like to, in fact, invite you to stage. Mr. McNamara, please. Mr. Malhotra. It's a pleasure to have you gentlemen over here. Mr. Malhotra, the stage is all yours.
Thank you. So, on my left side, you have already been introduced, Mr. McNamara. Thanks for coming to us and giving us your insights on what is happening on European side. So, because you can always learn, we are also in the process of forming the same kind of regulations or act, and it would be of great help that we can get your insights and how Europe is looking into it. So, sir, how has been your experience on working on this AI regulations, and how far you have reached? And what do you see that in what time frame you would be able to implement these regulations effectively? Because, ultimately internet is supposed to be free. And any government regulations coming to control freedom of press or any freedom is not taken lightly by various groups. So what has been your experience so far?
Well, the AI Act was passed in the last mandate of the European Parliament. It came into force during the summer in August. Various parts of it come into force at various times. There are prohibited practices. That part of it, the Commission published guidelines that were published on the 4th of February last, and enforcement will commence in August next. At the moment, a code of practice, which is becoming quite contentious, is being developed. It's a voluntary code of practice, yet because it carries with it a presumption of compliance with the Act, there's obviously a strong incentive for the companies involved in developing AI to participate in the development of the code of practice. So that's currently being developed. But you are, of course, right. I mean, freedom of expression is a cornerstone of all democracies. It's something that is dearly cherished across the European Union, and I think there is no desire to interfere with freedom of expression. On the other hand, I think it is important that because people have developed a trust in other human beings' decisions, that when in the context of news and current affairs in particular, that if people are seeing AI-generated content, that it is labelled as such, and the Act requires, it doesn't in any way stop AI-generated content in the realm of news and current affairs, but it is required that any content that is AI-generated, or indeed deepfakes, are not banned, but they have to be labelled as such so that people know that it's AI-generated rather than generated by a human in whom they could perhaps place their trust. Likewise, if they're interacting with AI rather than interacting with another human being, they are required to be made aware that they're interacting in a context outside of news and current affairs.
So you mentioned self-regulation. Do you think it will work?
I think it will. One of the other contentious issues, other than the copyright issue in the Code of Practice, is third parties inspection and the role of third parties in inspecting what is happening and in verifying what is happening. The developers, of course, point out the amount of industrial espionage that is currently at play in the sector and their fears with regard to that. On the other hand, I suppose for the public to have confidence, there has to be some independent verification. But I mean, that is one, I suppose, of the criticisms of regulation generally in the area of AI, that the regulators and the policymakers don't really understand what's happening, and only the developers understand what's happening. But I mean, in a European context, I suppose we've heard this before with regard to financial services, etc., and we know where that led when you have a complete self-regulation with no oversight. There has to be some oversight. Otherwise, I suppose there's an incentive for developers perhaps not to comply. So complete self-regulation won't work, but I mean a system primarily based on self-regulation, I think, can, once there is oversight.
Yeah. So, sir, Mr. Krishnan, sir, we have been interacting with you and have been having insights from you also. Today morning in the message Honorable Minister has given, he was also addressing two issues. One was copyright and second was this deep fakes or misinformation which is being generated via internet. Sir, how do you see, sir, that because we, DNPA, all members come from organized sector of media. They are all either licensed or permitted by the government to, whether it is their news portals or whether it is their news channels, they have taken license from government. But this whole thing which deepfake, etc. is getting generated from individuals who are not registered here. How do you see, sir, that the policy framework will come about and control these issues?
See, I think there are two parts to this question. As far as deepfake is concerned, I mean, that is one of the areas of concern with regard to AI. And I think India's stance on artificial intelligence has been that in terms of the benefits that it could result for Indian society, those far exceed whatever may be the harms that could come, and therefore our approach has to be such, to regulation or otherwise, it needs to be such that we promote innovation while at the same time protecting ourselves against the harms. And we've been very closely studying legislation and regulation in other jurisdictions, including in the European Union, to figure out at what stage it would be appropriate to venture upon something similar in the Indian context. You'd also be aware that we had a committee under the Principal Scientific Advisor to go into this whole issue of governance of artificial intelligence, including possible regulation, and how can we do it. So far, the stance has been that the existing legal framework in India, to some extent, is capable of handling issues like deepfakes and misrepresentation. Because both under the IT Act and under the Bharat Nyaya Sanhita, BNS, which replaced the IPC, deepfakes are a form of misrepresentation, or misrepresentation is a crime and you can take action against it. And existing law provides for that. And in exceptional cases where the limited number of cases where it affects, where it attracts Section 69A, which has constitutionally mandated restrictions on the freedom of expression under Article 19.2 of the Constitution. And let me remind all of you that Article 19.2 has about 9 clauses or 9 separate grounds, and 69A has only 6 out of the 9. And things like obscenity and defamation, which are covered under Article 19.2, are not covered under 69A. It is primarily security of the state, public order, relations with friendly states, and so on. So those categories of cases we can act on right away. And under the overall ambit of safe harbor, that is Section 79 again, of the IT Act, it is possible to act. So it is not that we are without protections already. Under Indian law, protections exist. And those protections are more robust, I mean, depending on how you look at it, more robust given Indian social circumstance than you would have in certain other countries where you will have to get a specific court order to enable this. Here, the executive itself is empowered to act. So to that extent, I believe there is defense currently available to address issues of this nature, and that need not be very high priority. At the same time, let me clarify, there are two kinds of issues. One set of issues is labeling, and labeling was handled in the advisory that we issued on March 15th, 2024, where we said you will have to label content, and we are empowered to give those kind of guidelines under the IT Act, and that guideline has already been given. We can, of course, have stronger provisions, and if the need arises, I guess the government will sort of bring in legislation to have stronger provisions to address issues of this nature. We have not ruled it out. But as you have seen with every piece of legislation that at least MeitY brings out, we have an extensive process of consultation, extensive process of talking to stakeholders before we bring out something of that nature. But if you ask me on today's date, our emphasis really is on innovation and less on regulation and less on these concerns. And we believe that actually even if we were to regulate AI in certain cases, and some of the suggestions we've been receiving are in that direction, it is to actually have enabling provisions. You know, look at the law to see what certain kinds of enabling provisions are required. Some of the liability provisions can be made more clear rather than just leave it to a civil law sort of issue, and try and see that, you know, there is an appropriate compensation to both sides of a particular issue, so that AI can develop and, you know, innovation can develop while liabilities are addressed. It may at best be on issues of that nature. So I think it's important to recognize that, and, you know, globally also, the movement has more or less been in that direction. November of 2023, we had the Bletchley AI Summit, Bletchley Park AI Summit. The focus was AI Safety Summit. By the time we moved to Seoul, safety got dropped. And by the time we came to Paris last month, earlier this month in February, which was co-chaired by India, it was called the AI Action Summit. So I think somewhere the emphasis is, you know, gently shifting more in favor of ensuring that AI as a force for innovation and what it can contribute to growth is what we focus on, while guarding against the possible harms and the downsides.
Very right, sir. Sir, like Mr. McNamara said that they would be appointing third-party monitoring agencies to control it. One problem, sir, in any act or regulation is that if enough monitoring is not done, then the effect of the regulation is lost. The challenge in internet is today in India we have probably less than 1,000 channels, out of which probably 400, 500 news channels, probably less than 1.5, exactly 1.46 publications which have taken permission from government to run their businesses. Internet, YouTube alone has more than 120 million channels. So monitoring all of them is going to be a cumbersome task. And most of the time what happens is that for every person caught violating any act or regulation or copyright, there are hundreds who are left. And that encourages them to come again through some other name, some pseudonym, and again start the same business again. Now, this is going to be a difficult thing. And how do you, Mr. McNamara, propose that eventually this will become an effective act or regulation? How the entire framework will work?
I suppose the AI Act, in truth, really doesn't deal with copyright it merely requires that the Copyright Act be adhered to, and the Copyright Act is a separate piece of legislation under EU law developed in 2019. At the moment, it's hoped that some modus operandi can be agreed between developers and copyright holders. Debate is quite fierce between them, developers saying that it's simply not feasible to outline every single piece of copyrighted material that's been used in the training of AI models. In the case of some of them, it's literally everything that's on the internet, and that it's not feasible to outline. And secondly, that it's perhaps a trade secret as to what they've used in the training of models, how much emphasis they've placed on some materials over other materials. On the other hand, the copyright holders say, well, if we can't ascertain whether our materials are being used or not, have been used or not, then the protections in the Copyright Act are essentially useless to us, because if we don't know when our works are being used, how can we claim compensation? That is entirely unresolved at the moment in the European context. It should certainly have to be hoped that some modus operandi can be agreed voluntarily between the bodies. I am aware that this matter is being litigated in the High Court here in India. I'm also aware that the issue is being litigated in the United States. I fear that if agreement can't be reached voluntarily between the parties, then the courts will be called upon to clarify here in India, in the United States, and perhaps in Europe as well. And as often follows, when the courts clarify a matter, they clarify what the existing legal situation is, but often point to a lacuna in the law, and that requires legislative intervention. It is, of course, I think, a particularly difficult area for legislative intervention, because it is going to require developers in the European context, in the development of this AI code of conduct, are being quite forceful at the moment in saying that if the code of conduct, as it's currently framed, is what is the final code of conduct in Europe, that they won't sign up to it, and that they won't deploy some of their models in Europe. And I suppose the threat of that is then that these models are going to be deployed elsewhere, perhaps here in India, perhaps not, certainly in the United States, in other parts of the world. And the further threat of that is that Europe falls further behind, because Europe has fallen behind the United States considerably over the past 20 years or so. So I'm afraid I don't have very clear or easy answers, other than to say that we're facing exactly the same dilemmas, difficult decisions, and adjudication between rights as you are here in India at the moment.
Yeah, you're right. One thing is there, whether it is AI-generated deepfake or copyright, both get transmitted via some platform only, whether it is Google, whether it is Meta. And I think these companies would also have the capability of finding out what is happening and how they can be also how they can also participate in stopping these malpractices adopted by people when such policies come around. So is there any effort in that direction, that to involve the big platforms, big tech, so-called big tech also, so that they also help out governments in controlling these menace?
I mean, the regulation falls upon them to adhere to. So, I mean, the requirement that it be clearly labelled will also fall upon them. I mean, obviously, even in the realm of music now, I mean, you have Spotify lists, and you have some tracks. You've lots of tracks that are by recognised artists who hold a copyright over that. Increasingly now, you have tracks which are AI developed, which are being published with them. That there will be, it would seem to me, from my interpretation of the AI Act, that there will be a requirement to differentiate between that which is human produced, over which human beings will hold copyright, and that which is AI produced, and that all media operators, including the big tech companies that you've outlined, will have to make that differentiation.
Great. Mr. Krishnan, one request from all DNPA members would be that whenever any regulation is around the corner, the responsible media follows that. but it should not mean that there should be an interference in freedom of creative writing or freedom of press, and whatever regulations come around should be effective, because ineffective regulations will lead to anarchy.
I think there are three things, and I just go back to the earlier question you raised, that there is some which is curated content which comes on and some which is uncurated content, and some of them register and some of them don't register. And frankly, I think your characterization of the Indian media that it's government licensed and things appears to give the impression that government sort of controls everything about it. And I think that's not a fair characterization of Indian media. I think it's free and fair, and you have every right to put down what you want. In the digital space, there are certain kinds of media which is curated in terms of there's an editorial content and an editorial policy as to what goes in and what doesn't go in. And that's what you refer to. And then there are others who are, who just put what they feel like and upload what they feel like. And some of it goes viral. A lot of it just sinks unnoticed. Ultimately, it boils down to the same point that Mr. McNamara said, a question of trust. Whom will you trust and what will you choose to read? Would you rather read something which you would trust and has been curated, has been verified, and it is content which you can actually believe, as opposed to some fantastic claims somebody makes, right? So this is the essential differentiation, that I think good quality content is something which will drive out the bad quality content in the long run. That is a marketplace where you're looking for possible consumers, and I don't think it's in anybody's interest to say that we try to, very tightly regulate this or tightly control this. I don't think as a free society we want any of that, and frankly, I think, in all the years, there's one habit that I've had is to consume news through, multiple channels in terms of reading newspapers or looking at it on the internet. And I think I'm grateful that in India, it's always been good to read what gets carried in the newspapers. And I can, without naming certain countries, and likewise, it's very interesting to read what gets carried in democratic countries, including in various parts of Europe or the United Kingdom or even the United States. And there are certain other jurisdictions where you don't even want to look at the newspapers. I'll be honest, and I think it's important that we preserve that. And to that extent, I think it's very much in the hands of the news publishers in terms of what content is, how good content will drive out the bad. That is a marketplace for ideas. The second part of it, of course, is that, that you should be fairly compensated for the effort that you're putting in to actually curate the content and bring it out there. And that's the same point that Mr. McNamara made in terms of, how do you sort of this contest between the two elements. One part is, because the theme here is AI, one part is, scraping the internet and picking up the content. That, as he said, is subject matter, is sub judice right now, and we'll have to await that, what happens. And I know DNPA also is probably party to that particular litigation, so let's await the outcome of that. Let's not prejudge that. The other part is the kind of other restrictions that we place. And as I said at the beginning of my answer, the restrictions are on very, very limited grounds. We try our hardest to make sure that we fall squarely within the law. We are accountable. This is something which is recognized by our courts. And if we step beyond that, step beyond our executive powers, we are answerable to the court, and we would like to stay within those clear limits. And as far as the enforcement of it is concerned, I think the enforcement of it has also been, we have not had issues over the last 3 years. Whenever there has been a need to take action, the enforcement has also been effective, and sometimes more effective than some of you would like, but the enforcement has been effective. The question really is that, there's so much of content, you can't really look at all the content. It's only what catches attention and what comes up and what gets flagged. And because there is a process, when we take action under these provisions, somebody has to bring it up. Somebody has to actually complain about the content. Unless the content gets complained about, you really can't get into it. And I think If somebody is not complaining about some content, then it's just not getting the viewership. It is just good media driving out the bad, or good content driving out the bad. So I think that is also socially a desirable outcome.
Thank you, sir. Thank you for your reassuring words. And we hope we will see to the new regulation soon, or the policy regarding this soon. Thank you, Mr. McNamara. Thanks for joining us. Anybody has any questions in this to the gentleman we have on podium? Yes, gentlemen.
Platform responsibility is fairly clear. This is in the context of Section 79 of the IT Act. In case the platform actually has any kind of editorial content or violates a clear guideline that has been given, right, then they are liable. Otherwise, the platform has safe harbor in the sense that he's just carrying third-party content and the third party is liable. But on the other hand, if they pick and choose saying that I put on this content or I don't put on this content or I edit this content, if any of that editorial control is there, so those are the two exceptions to what is there in 79.1. It is contained in 79.2 and 79.3. Or they violate any guidelines which have been given by government saying what needs to be done, and those are contained in Rule 3.1b of the IT Act. So if it violates any of those guidelines, then the safe harbor doesn't apply anymore. But quite honestly, our law enforcement agencies and others have been a little reluctant to actually use that provision because, you know, when you're filing a case or when you're filing a complaint, a criminal complaint, then in addition to the person who's posted that particular piece of information in the social media, in addition to that person, they have to also prosecute the platform itself saying, why did you carry this content? They've been generally reluctant to do it, but platforms have been very responsive. When cases like this are flagged, they take down the content. So it sort of works both ways.
Anyone? Can you give mic here?
So this is a question to both of you. A lot of countries have now, you know, with the whole democratization of content, there has been a case where a lot of people are being hounded, a lot of people are getting, you know, subjected to a lot of trolling, good or bad. And there's a lot of cases, especially for youngsters, right, in terms of mental health and a lot of issues which are coming up right now. Some countries have enforced laws which say that now youngsters should not be exposed to such things, so they're protected. Is there something in India, in Europe, you know, specifically that we're working towards that kind of mental harassment which happens, which is kind of connected to the whole like freedom and democratization of content?
I'm not aware of content at a European level, but certainly in some European member states, including my own, legislation has been brought in regarding online harassment of people generally. I'm aware that there was online harassment of some politicians, even in my own constituency. But interestingly, a prosecution was taken, but it was taken under a relatively old Telecommunications and Telegraphy Act. It was deemed to be adequate. I think the piece of legislation was perhaps from the 1960s, if I'm correct. With regard to younger people, I'm not aware of any specific legislation, but I do know that the Ministry of Education in Ireland has taken a step to introduce a code for schools whereby children are required to hand over their mobile phones on entering the school, and it's retained until such time as they leave. But of course that doesn't tackle the fact that much of the harassment and bullying takes place at home, and I suppose it is a horrendous environment. At least children who were bullied in schools before could go home to the safety of their home. Now they go to the safety of their bedroom and are being bullied there, and of course it's having horrendous consequences on their mental health. It's a very difficult thing to address by way of legislation, though. However, likewise, criminal prosecutions were taken against an adult who was harassing young children, blackmailing them effectively to send him sexual images. Through gradually they were sending images, and then he was using those to get more and more images. He was prosecuted in Northern Ireland under UK legislation and received a sentence. That harassment resulted in at least one child committing suicide. He received a sentence in excess of 20 years. It was a fairly high-profile prosecution in the last 12 months. But I don't think there is specific legislation around young children that I'm aware of, and certainly not at a European Union level.
As far as the Indian case is concerned, I think if there is a case of online harassment or online bullying, then it's just a mode. It's still an offence under Indian law, and you can continue to prosecute cases of that nature. I fully endorse what Mr. McNamara said about various aspects of bullying and so on, and it's not just a problem that can be solved legislatively. I think there's a lot of social action which needs to go about all of this. But the second part of the story really is about, the age gating part of who can join and who can't join. And as you're aware, we put out the rules under the Digital Personal Data Protection Act. The rules have come out now, and the Digital Personal Data Protection Act requires that, valid consent is required before you share any information with in an online format. So technically speaking, social media and other companies are also bound by that, and when somebody joins up as a member, a duty is cast on them to ensure that either they are adults or they have verifiable parental consent before they've joined the social media platform. There are certain limited exemptions which are there in the rules. For instance, a school needs it for the purpose of sending emails and so on, and an email account has to be open. So those kind of cases are exempt from this provision. But overall, we would expect the fact that nobody is then on social media. A child is not on social media without parental consent. That would be the situation which would arise, the idealized situation which would arise from such a requirement. And to that extent, presumably, they would be protected. But I think ultimately it is a social phenomenon which needs to be tackled through a number of other measures in addition to just the legislative.
So if there are no more further questions, I would like to thank Mr. McNamara, Mr. Krishnan for joining us and giving your insights on this very contentious topic. Thank you very much, sir.
Thank you, Mr. Krishnan, Mr. McNamara, and Mr. Malhotra for that very insightful and engaging discussion. It was wonderful having you here with us at DNPA Conclave 2025. I'm glad that you shared a very holistic approach towards AI development. Ladies and gentlemen, we are now breaking out for lunch. When we come back, we have a lot more to talk about on AI and media transformation. Request you to reassemble in the hall by 2:15 p.m. sharp.